The biggest mistake I have ever seen on a simple will, and I don't like the term simple will. I've never actually drafted a simple will. Every will has some complication. Every family has something unique to them that makes a will not so simple, but this is the biggest one I've ever encountered. My name is Philip Bruce. I'm an estate planning attorney here in Minnesota, and we were in probate. Probate is the administrative court proceeding where if I die, my stuff gets divided up, right? We have to have something that controls this process, and that's what wills do. They control this process. And what this will said, it was actually drafted by an attorney, which was surprising because this was not well thought out. What it said is, I give to, I'll make this up, Jane Smith, my truck. And that's what it said. And you might think on its surface that that makes a lot of sense. I'm giving to Jane Smith my truck. This will was 20 years old, and this person did not have the truck, the same truck that they had when they drafted the will. So what did they mean? There's three things missing here. First, we need to be much more specific about which truck. So for example, to Jane Smith, I give the truck that I have at the signing of this will, or I give the 1992 Chevy Blazer that I have at the signing of this will. Great. Then we need to know, if you don't have this exact vehicle, what did you mean otherwise? Does the gift go away, or do they get something else? Do they get whatever vehicle I happen to have at the time of my death? Do they get whatever truck I have at the time of my death? You know, when the person said truck, did they mean any truck I have? What if the person downgraded to like a sedan or something like that? Did they mean any vehicle? What did they mean? We don't know. And then also, if something, one of the biggest issues here was the woman, Jane Smith, in this situation had passed away. So what happens then? So the way to draft this was not to say, to Jane Smith, I give my truck. The way to say this was, to Jane Smith, if she survives me, I leave the 1992 Chevy Blazer that I own at the time of the signing of this will. If I no longer own this truck at the time of my death, I give fill in the blank. Any vehicle I own. The truck I own, if I own a truck. If I don't own a truck, this shall lapse. Or if I don't own a vehicle or a truck at the time of my death, or I don't own this truck at the time of my death, I give her $10,000. Whatever it is, you got to say what happens, so you got to bring it to its conclusion. And then we say, if Jane Smith does not survive me, this gift shall lapse. It goes away. Or if Jane Smith does not survive me, it goes to her children. Or if Jane Smith does not survive me, $10,000 shall be given to a charity, whatever it is. But you gotta do all three of those things. And if you don't do that, you've got a really risky document. One of the biggest problems with do-it-yourself wills, again, this one was drafted by a lawyer, but one of the biggest problems with do-it-yourself wills is this kind of stuff, and it just creates a disaster. We had to have a judicial settlement agreement, which was like a big agreement contract everybody had to sign. It was very expensive. Very expensive for one poorly drafted sentence. My name is Philip Bruce. Please do contact me with any questions. Shoot me an email.